Actually, refresh this page. And there it is. 20 since I started.
Since I was a kid.
That's cool.
It's the try before you buy, and it seems like it goes both ways. It allows us to try before we.
Well, and it just works the same way with us. Except admitted students are just conditionally better to go forward.
Isn't there a delay?
But they meet all the requirements. We won't have anybody in those classes that can meet the sessions requirements.
I'm in the camera. It's not moving.
And it just serves a lot of functions. The problem is we have.
Oh, there it goes. Oh, okay. Yeah, it's real fun.
Even we're admitted with George, tell me they're not going to come to Lincoln to take 2 classes that we go to George better prepared.
Oh, no, it is delayed.
The other thing I was thinking of is students who talk to who are thinking about this. We're going to go pretty early start programs.
Yeah, thank you. I think I'm very nice. Thank you. That's perfect. Let's see, we're just waiting for the recorders to be ready. Maybe they are. We're ready. Welcome, everyone. My name is Greg Brandis. I am the present chair of the Rules Advisory Committee. I want to welcome you to this first webcast meeting of the Rules Advisory Committee. We will, in a moment, introduce ourselves. I will share just a couple of thoughts about protocol as we begin, as much as this is the first meeting in which we'll be broadcasting. First of all, it's very important that we comply with all the open meeting rules that apply to this body. And in that regard, I will ask that our non-members of the committee or non-staff not be seated at the table along with the voting members. Staff of the State Bar are welcome, but others who are not would be asked to be seated in the seats at the rear of the room. Because we are webcasting, if you speak, for example, in public comment, but also to staff members and members of the committee, a reminder to use your microphone so that audio can be picked up and transmitted along with it, and also to identify yourself before speaking so that our members of the public who are viewing the meeting at a distance will be able to identify you as they are listening. I will offer opportunity for public comment. I will offer it at the beginning of the meeting on matters of general concern or any particular issue on the agenda. I will also be willing to offer it at the time of an agenda item, following the staff report on the matter and before the committee discussion. So if you have an interest in speaking in either of those venues, would you please so indicate by raising your hand at the moment on any matter that comes before the committee? All right, it looks like there's none at the moment. If there are later items on which you'd like to speak, go ahead and indicate at the time of the item. We'll call that our call for public comment. If you do comment, I would ask you to be reminded that we would like you to limit comments to about 3 minutes so that we can move our agenda through its requirements. Council, have I forgotten anything?
You're doing excellent. You're doing excellently.
Okay,
Good.
nothing left to chance. Thank you. One last call for public comment to make sure I check that item off effectively on the list. Okay, general public comment is closed then. The next item on our agenda is the draft minutes of the meeting of February 1st, circulated as attachment A. I don't know if any member of the staff, or George, do you have any comments about the minutes or suggestions, or does any member of the committee have comments or corrections for the proposed minutes?
No, I'd move to approve.
All right, so motion and second. Is there any further discussion? All those in favor?
Aye.
Thank you very much. Now, Council, do we have to take roll call votes on something like that?
I do not believe so.
Okay. All right. Just making sure that we're doing it the way we're supposed to. In the chair's report, I have very little to report. So primarily covered most of those in terms of reminders at the beginning of the meeting. So let's turn our attention to the staff report.
Alright, so I'm Amy Nunez, Interim Director of the Office of Admissions. This next item, the next two items, that is the exam statistics and report of the taker versus completer in relationship to the required reporting, as well as the implementation of the minimum bar passage rate are correlated. As you may recall, the first item on the taker versus completer was an agenda item that appeared on the CBE agenda for February 2nd of last month. And that item specified and provided more guidelines on how we are going to calculate the bar exam statistics. Specifically, looking at the concept of completers versus takers. And that would mean that in previous guidelines, in February of 2017, the CBE decided that, voted in that we would not include people who did not complete the bar exam. And that was specified by looking at who took the exam and who received a 0 as part of that calculation. And the last CBE meeting in February, it was decided by the CBE that we would actually look at who completed the exam. And that definition involves looking at who came to the exam and sat through the entire exam process. That is going to be a completer, and those that complete the exam would be included in all of the exam statistics that followed the bar exam and get reported in the results. So this next item, again, that was voted in February. So the next item on the implementation of the minimum bar passage rate, what it does is this proposal that's on this agenda for tomorrow for the CBE proposes to take the completer definition and apply it to the calculation of the minimum bar passage rate. So specifically what that means is students who complete the exam, and that definition again is sat through every portion of the bar exam, will be included in the statistics. So theoretically, if a student were to, or I should say an examinee, sat through the exam and decided not to come back in the afternoon, they would not be considered a completer and would not be incorporated in the bar exam statistics. So this is a proposal that's going to the committee to apply that completer definition to the minimum bar passage rate calculation. So that proposal's on the table tomorrow. It also includes a recommendation. There are two components. Sorry, I'm trying to remember the second one. That we will also provide the names of students who fall under that definition, completer, to each of the schools in order to complete the calculation for minimum bar passage rate. So given that it incorporates the last 10 bar exams, so that would be bar exams starting from August 2013 to July 2017, we will be providing those lists to the schools as to who should be removed from the denominator in that calculation. That's what that proposal entails.
Right, so just procedurally, this is not an action item, obviously, for the RAC at this time, but let's offer if there's any public comment on those matters. Right, seeing none. Discussion among the RAC members about those matters?
Just a quick question, Amy, if I understand. I understand that each school would receive a list after we get our pass-fail or with our pass-fail. What about, I missed whether or not previous.
Yes.
Yeah. Did we receive those already? Those of us who
We
have?
will retroactively send you all the names from 2013 to 2017 to ensure that you're able to complete it for this next required minimum bar passage rate calculation.
Hasn't been sent
It has
yet.
not been
Okay,
sent.
good. Thank you.
So Amy, a question I had when I listened to this and I read this is, do we know how many people, say on any given bar exam, have started taking one portion of the bar exam and then decided for whatever reason they don't want to finish?
Yes. Yes, we have calculated that. And Lisa's
What's
here.
that? So, and approximately?
Okay, so for February, it's approximately 50 to 60.
Okay. Is that
That's what
pretty?
we've been seeing.
Okay.
Which is approximately less than 1% of the total bar takers.
Right, because I remember the discussion, which I thought was a little bit incredible, but I guess it's true, is there was a concern, and I think we have to just address it, a concern that people could be gaming the system. They could come in, decide that they're, well, maybe today I'm not gonna do it, and then they don't count. And so that was, I think, the concern that people had about when we went to what I thought was a more fair way of calculating. If they finish it, we're gonna count it. They're takers. If they don't finish, we're not gonna count it. But that's just something I thought we'd raise in terms of discussion.
Other discussion? Members on this one? I mean, Karen, I think it's a good question, and I know a lot of really good staff work has now gone into kind of refining this proposal, and I suspect a terrific amount of time spent collecting the data that you just mentioned is going to go out, but it's important, I think, for us to recognize probably how long it took staff to wade through all those records to discover who and which schools and all the rest of that. That would need to be sort of an addendum to the data previously provided. So thank you for all the work that went into all that. I don't know who exactly did it, but our thanks are with you for trying to work through those issues. As we've discussed before, it's critical that we are all speaking the same language when it comes to these items, particularly matters that are disclosed to the public for public information, public protection, like pass rates. And so everybody on the same page is absolutely a terrific thing, and we know how long it took. So thank you for that. So anything else on these couple of items, conversation? All right. Mimi, do you want to proceed with the remainder of the staff report?
Turning to the status of the proposed rules, statute, and guideline revisions respecting unaccredited schools, unaccredited law schools and distance learning. I want to give you an update. We talked in the past about the mandatory accreditation proposal and the proposal for distance learning schools. One of the things we talked about last time was bifurcating the two. The sort of the potential of bifurcating the two issues, because one requires statutory change and the other does not. On the mandatory accreditation proposal, one of the things that we heard from conversations that we had with legislative staff is they wanted to hear what all of the unaccredited schools felt about the proposal, because they certainly recognize that there are cost differences. And there may be access differences, unaccredited schools in areas where maybe there aren't accredited schools. And they wanted to get a sense if the schools were worried about being put out of business and they wouldn't be able to provide services to that community. Amy has been reaching out over time. She reached out to all of the unaccredited law schools and reached out to some of them multiple times. At this point, she's only heard back still from, we're getting closer. It had been sitting under 10 for a while, and I think now maybe at 12, 13. But until we can provide the legislative staff with that information, we can't proceed on this proposal. They were very much interested in receiving this before they made any decision to go forward. That's part of the reason why we were talking about bifurcation of proposals, because we can go forward on the notion of allowing accreditation of online schools, of distance learning opportunities, because those were rule and guideline changes only. And so Amy and Natalie are working on putting together a timeline and a process for how we can roll that out. But the expectation is that we will be taking soon the sort of the initial steps that we need to do in order to be able to roll this out sooner rather than later.
All right, terrific. So for the folks at home, as it were, that was Donna Hershwitz, Chief of Programs for the State Bar, reporting on the status of that one. So having had the staff report, let's open it to public comment on that, if there are any, before we move to the RAC discussion. All right, members of the RAC, questions or concerns or comments about that?
Just, I know that we've gone through the process for amending the guidelines for purposes of allowing for more online learning or 100% online learning. Are there incidental guidelines that we didn't get in that net that we need to look at? And I don't know whether we've identified those so that we're tracking along with the timeline.
Well, let me start with a little bit of the history of those rules, because I lived it along with a few other people here. This began in 2012 when the Board of Trustees identified among its priorities for the year examining unaccredited law schools and whether or not to continue to permit them to operate. That ultimately became a task of the Committee of Bar Examiners sometime in late 2012, early 2013. Sometime in 2013 or 14, we began the process referred to as the Rules of the Rules Working Group, which was appointed by the Committee of Bar Examiners and comprised of bar examiners and deans of all state accredited and unaccredited law schools in California, representatives of each of the groups. That group worked for something like 18 months to prepare a proposal, which was then brought to the Committee of Bar Examiners. In that process, Jackie, to respond, there was a pretty extensive coverage of the rules, not much work on the guidelines, because it was felt that it was necessary to address rule changes first and then work on guidelines. So those rules were brought to the Committee of Bar Examiners, passed by the Committee of Bar Examiners, recommended to the Board of Trustees, passed by the Board of Trustees, and ultimately went to the Supreme Court, who said, as I understand it, that's not quite enough information for us, and sent it back to another round of Rules Working Group meetings. That was another 18-month process or so, and those two processes culminated in the new set, which includes both rules and guidelines, as well as statutory changes and changes to Supreme Court rules governing admission practice that were presented to the Committee of Bar Examiners last year and approved by the Committee of Bar Examiners, recommended to the Board of Trustees, approved by the Board of Trustees, and in November, I believe it was, the Board directed that those be delivered to the Supreme Court for their review and consent or guidance on them. And so it's been a lengthy process in which all of the aspects of the rules have been considered. I think your question is still a good one as to making sure that in this transition process that nothing gets lost. But I think in terms of what's in the rules, the issues have been addressed in terms of the proposals that are being worked through. So I don't know, Donna, if you have something to add on the process of what's being done right at the moment, but certainly there was a comprehensive review of how things were interconnected in a couple of occasions.
Yeah, and in all likelihood, since they were originally considered separately from the mandatory accreditation, in all likelihood, everything was caught, but you can never do enough reviews, right? So I think it is absolutely a good idea to make sure we do that additional review, especially now if we're looking at it in the context, again, of potentially being separated from mandatory accreditation and just making it an option, just making 100% certain that we don't say, okay, everything's in place, we're going forward now, and then discover there was something else that needed to be changed, so we need to go through a whole new process. So yes, we should definitely build that in. And Amy and Natalie and I haven't sort of talked through what the ultimate plan would look like, but it probably would behoove us to, when we develop the plan, take it ultimately to the Board of Trustees just to be clear that we're bifurcating the two, and that this is that we're going forward with the rules and guidelines that allow the accreditation of the distance learning schools.
Thank you. George?
Well, I just, drilling down about 3 levels, I mean, I know for a fact that the way the rules and guidelines were written in a way that we didn't foresee bifurcation, and there's a particular timeline set out, if you recall, with regard to the assumption that legislative changes would be made and then the school would then. So some of that language now would be superfluous and probably best eliminated. Just just gonna streamline that, and then you could always go back down the road. So if you look at them from the perspective that there isn't gonna be this legislative act, probably more than a few of the rules or documents should be further amended.
All right, are there other comments or questions on this one? Okay.
Who would be responsible for taking a look at those guidelines and seeing what further amendments need to be made?
Is that you all?
I would be happy to agendize it if that's what the direction is.
Okay, I just want to make sure it was in somebody's wheelhouse so that it didn't get lost in the process. And I know that staff has a lot on their plate, so to the extent that we can take on examining, making sure that that the rules are as clear and any changes that need to be made, we can bring forward and take it through to the CBE, et cetera, in a timely way. I mean, I would be happy to work with Greg on that.
Yeah, procedurally, this is going to the board, not to the CBE. That's
So it certainly could go to CBE first, and that would be a normal process. If we're recommending further changes to the rules and guidelines, it would normally go to CBE first, and absent sort of a separate discussion with the chair and vice chair of CBE, I wouldn't see a need to deviate from that typical process.
okay. So staff work for the next time around, we'll get together and talk about what to get ready for the next meeting, for the next RAC meeting. Great. Anything else on that issue? All right. Amy, you want to continue with the status of state bar studies?
Yes, the last item on here is the status of the state bar studies, and Ron Pai has joined us to talk about both the law school performance study and the job analysis, upcoming job analysis study.
Well, my name is Ron P. or Pai. I'm analyst with the Office of Research. In many different other occasions, I have discussed the next bar exam related study, which is the occupational analysis or job analysis of attorney practices. It's an extension of the previous two studies that we completed last year, standard setting studies and content validation. Partly also following the statutory requirements that was put in place last year to evaluate the bar exams in terms of standard content, or following the normal cycle of conducting this study, these kind of studies, which you start with a job analysis, and then based on the results of the job analysis, to look at the content, and once you complete the content analysis, to look at the standard setting. So we're going back to a beginning of this kind of a normal cycle, and the scope of the job analysis is wide-ranging. And in the past few months, we're in a information gathering process, also pending priorities of other projects. In the next few months, we're ready to launch the project. I have sketched out a rough timeline for the project. And just to give you an update about the major milestones that we're planning to embark on in the next few months is, next month we'll be ready to issue a RFI, request for information, or request for proposal to seek a consultant to conduct the study. Actually, last week we attended a workshop conducted by the Department of Consumer Affairs in Sacramento. They are in constant process of evaluating this kind of a study for a variety of licenses. They invited us to observe their process, and it was very helpful for us to understand one part of the process, which is after gathering all of the survey results, they have subject matter experts to evaluate the results of the survey, make a decision about the adequacy of all of those survey results as measured by importance, frequency, and criticality of the different tasks and knowledges that were sent out to a particular occupation that they are trying to assess the validity of the exam. So after issuing an RFI or RFP, Concurrently, we'll also need to form a new working group. The formation of that new working group will be guided by the existing bar exam study working group. And the scope of that new working group, we're aiming for some national representations with expertise in the bar exam at a national level. That new working group will guide the study for the rest of the project. Once we identify the consultant to work on the project, we're planning probably reasonably to have a kickoff meeting sometime in June or July to plan out the subsequent activities that's guided by the consultants. And at that point, the working group will play a very important role in determining the scope of the study and then also the selection process for subject matter experts. Subject matter experts in this particular study serves a very important role in initially just determining the content that we put into the survey questions. And from that, focus group discussions with the subject matter experts, the following steps will be the development of the survey questions. And how we send out the survey questionnaires, that's something we'll also want to consider different ways of doing it. Because the survey results, one of the important elements is the response rate. If you get a 10% response rate versus 3%, I think one of the survey responses from the Department of Consumer Affairs is very small. That raises some issues. We want to get to as large a population of the survey pool as possible so that the results is reliable. And there are a variety of ways doing that, either by delivering the survey questions through online or some other method that we're currently exploring. There are other methods would require development of software, so that's another different track we're trying to explore the possibility. All of these will take 3 to 4 months before we have a questionnaire. And throughout the process, one of the things we want to make sure is to always keep all the major stakeholders involved and updated on the process so that the questionnaires, when ready to send out, we also have a solid contact to look at the various dimensions of the occupations, whether it's frequency, importance, criticality. These are typical kind of questions, but a lot of times there are ambiguities in how you construct the questions and then making sure that the result, the final measure of the criticality actually is accurate and reliable. So the overall timeline for projecting is sometime in June next year we'll have some results and be ready to look at the survey results and finish a final report and then going into a public comment period. So that's a rough timeline. Without the benefit of consulting with experts in doing this kind of a study, but in the past few months, I have a pretty good sense about the major milestones. And we're ready to launch into the study starting from next month.
Okay, thank you, Ron. Before I take comments from the RAC and public comment on this matter. All right, seeing none? Dean.
Ron, I just had a question. You indicated that you're looking to put together a working group with participation on a national basis. Are these bar examiners throughout the country, or legal educators, or psychometric individuals? We were talking about the working group. I was just curious about who you had, what you had envisioned as far as participation at that level.
What I have in mind, not so much the technical aspect, like involving other psychometricians to be part of this. It's more along the lines of experts who have intimate knowledge about the recent changes in development of the legal market, legal practice, legal education.
So not bar examination.
Bar examination, I think that part probably would rely on the psychometrician to give us guidance. But also in the meantime, we'll be in close coordination with NCDE. I heard that they're also in the process of doing their own job analysis. So there will be some coordination, making sure that our study, in terms of the scope and the final results, is consistent, or at least in alignment with what they are trying to do.
I would just hope that when you're looking at the scope, you look at not just the subject matter and topics, but also the format.
Yes.
Whether it be performance, practical skills based versus actual subjects on the bar examination. As a lot of people know, I used to be the director for examinations, and I did things on a national basis. So, and I still regularly do business, not business personally, but I'm in contact with people from many different jurisdictions that are responsible for the development, administration, and grading of their respective bar examinations. So I'm volunteering that if at some point I can provide any information, I'd be very pleased to do so. These are states that do not use the UBE, because the UBE is in Uniform Bar Examination, of course, is in many states, and that exam is one thing, but the examinations in other states, such as Virginia and Louisiana and Ohio and Florida and Texas, are very, very different. And I'd be happy to assist in any way I can.
Yeah, format is very much in my mind when I talk about scope or the purpose of the study, because you could look at just the breadth and depth of the knowledge when we talk about the scope. But in our conversation with the Department of Consumer Affairs, I also raised the question about the result of the job analysis study, whether they always use it to evaluate the adequacy of the existing exam format. The response is there are some standardized format is widely accepted as valid format, whether it's multiple choice questions or essay questions. But then in some occupational licenses, they rely on other non-traditional kind of exam format, like computer adaptive multiple choice or vignette-based video-driven kind of exams. All of these formats, I think, at least in terms of the overall scope, we should be open to consider depending on the results of the survey results.
And I agree 100%. And I would also suggest that you look at the time allocation for the different formats instead of, my recollection last time we studied to go from the 3-day exam to the 2-day exam, there wasn't a lot of time. But I've spent on looking at the difference of between a 30, 40, or a 60-minute essay question, and the ability to bring in 30 and 40-minute questions that are used in many jurisdictions very successfully as a means of applying. So you have the subjects on the bar examination, you have the different components, whether it be performance test essays or multiple choice, but then you also look at the time allocation spent between performance tests and essays, and how do you get the from a psychometrician standpoint, the requisite number of questions of essays within the time period. And I would hope that time be spent looking at 30-minute and 40-minute questions that perform quite well in many jurisdictions, as opposed to just being focused on the 60-minute questions, because then that limits what you can do with other components of the bar examination.
I had a question. Ron, thanks for the report. As it relates to this idea of this new working group and having national representation, that's the part I think I'm a little unclear on. Are we thinking about it from the point of view, the job analysis being the delivery of legal services and how that's changed over time? So would we be looking for people that are leaders in the field of what we do every day, as opposed to, an educator, and I think that's somewhat what Dean said too. I'm trying to figure out how we think that working group will be staffed. Because I think that's really interesting, because we think on a job analysis, and you're right, NCB is well on their way in terms of doing a revised or an updated job analysis. I think we do need to think about what we're trying to accomplish. And it was my understanding that what we were trying to accomplish was an identification of what entry-level lawyers are actually doing in the field. Because those of us that have been in the profession for a long time know that that frankly has changed to some extent, quite a lot, depending on the subject matter or the area of specialty.
Right. Area of specialty, that's the question that we'll get the answer from the frequency of different practices or tasks. But in terms of the national representation in specific domain of the legal practice, that typically is the protocol in job analysis, whether you do it every 5 years or 7 years. The focus is really trying to identify recent changes or trends in the practice. We all know there's a lot of changes in technology and the extent to which it might affect legal practices and legal education as well. So those are the things that we want to be sure that whatever recent changes and trends, we are not just looking at the regional changes, but also at a national or even international scope, because a lot of these changes, depending on the stage of these new technology, could change very quickly. So we want to be mindful of these potentially important impact on legal practices.
So Ron, I actually have two questions. Excuse me, so what you just said, leverage one of those. When it comes to the selection of the working group that will guide the studies, have you developed sort of a framework of guidelines for what those seats should represent in terms of skills and experience and background? There's a tendency in these, right, to go find people who are willing, or go find people that we know, or go find this, that, or the other thing. But ordinarily, it's better to begin with kind of the definition of those roles, to then begin figuring out who might be appropriate to those slots. Has there been consideration of that? And then the second question was regarding if you have a sense of how many consultants are out there who are qualified to conduct these kinds of studies on the sort of scale that the bar is undertaking, with the kinds of specialized expertise that the bar requires. If you have any sense of how many vendors there are for something like that, I'd love to hear your thoughts on it.
The first part of your question related to the process of forming a working group. I don't have a lot of detailed thoughts about it, but then the process that we followed last time in forming the working group, not the working group, but actually the subject matter experts participating in the two studies, the standard setting and content validation, that's based on different entities nominating subject matter experts, whether it's Assembly, Senate, Supreme Court, law schools, State Bar, so that we make sure we have all of the different stakeholders covered. The individuals from all of those entities would depend on those entities nominating from their experience the best candidate. That probably is not a bad model, at least to get started. The working group is still discussing these issues. I think that we are still maintaining the existing working group meeting. So these are the subjects that we're trying to clarify as we go forward. The second part, what was the second part of it?
It's always the peril of asking two questions at once. What was the notion of how many vendors or how many qualified folks might be able to respond to the RFI or RFP you anticipate issuing?
Even though the key component of this study is to construct a comprehensive and detailed survey, so presumably survey companies will be able to do that. But I have a different view because the ultimate goal is to define the practices that's to meet the minimum competence definition. So this consultant has to have a lot of experience, not only in psychometrics, but also in different occupational analysis. And I asked the psychometrician who conducted the study last year, he gave me a list of a few survey and psychometrician entities who are experienced in doing this kind of a study. So in our RFI, I'll make sure to send it out to those entities to participate in the bidding. And Department of Consumer Affairs, certainly I was impressed about their work. Every year they do this kind of study for more than 40 different licenses. They're a strong candidate. I wouldn't say they are the stronger than anybody else because I don't know about the others yet. But all of these, in my mind, I have 5 or 6 that I know of. But once we send out the RFI, we'll just go through a formal evaluation process. The existing working group will participate in that evaluation process.
Good. It's good to know that there's at least more than 1 or 2 that we think are possible qualified vendors for something like this. It is, obviously, Karen, as you said, what we do is much more specialized than some other professions, not more specialized than some other ones, but it does take some content domain expertise to even frame those questions effectively. So I think whatever structure the working group adopts for that, it needs to bring into that process the appropriate subject matter experts as well. And I want to go back actually to this notion of deciding what you want before you pick people. I agree with you, Ron, that it was an expedient and appropriately, I don't want to say political, because that sounds more negative than I mean. It was appropriate to addressing the various stakeholder needs to ask for nominees from various stakeholders. And given the time constraints and all the rest of that, it was understandable. But in so doing, the panels that resulted were a polyglot of kind of different levels of expertise and interest, and what folks brought to the table was not necessarily representative in some cases, or they came with a set of issues that were bundles that went along with where they came from. Again, I would urge upon the working group strong consideration of defining what skills, experience, knowledge, and expertise needs to be on the working group that manages this study, and in some fashion incorporate that along with appropriate access of stakeholders to pointing people to that group, because otherwise you'll get what you get from whatever political processes those groups undertake to provide you, and that will not necessarily establish the expertise that's needed for something like this. So just a request for those of you who are continuing on the working group to give strong consideration to essentially job definitions for those positions. All right, are there other comments on this one before we depart from the members of the staff? All right, well then I will thank staff for their hard work and their good reports, and thank you, Ron, and thank you all for the work on that. That takes us then to item E on our agenda for the day, which is the proposed new guideline 5.1. This is regarding credit for courses that a student may complete as a visiting student at one of the California accredited law schools. And Jackie, would you introduce this for us a little bit?
Sure, and I have to apologize to the committee because the wording has changed a little bit based on some very helpful comments and feedback from other Cal deans. But let me give a little bit of background. First, it's it's guideline 5.10. I know, but then that was even.
Oh, even that. Okay.
It's a proposed guideline 5.10, not 5.1, just to be clear on the record. So just to give a little bit of background, there are in the ABA world and even in the CALS world programs that are kind of like BA to JD or undergraduate to JD programs that allow undergraduate students to matriculate into a JD program, transfer back JD credits to the undergraduate program, and also share those credits with the JD. And it's a way for schools to both create a pipeline into legal education, as well as to cut down the cost and the time necessary to complete both the undergrad and the JD. That does require that the student matriculate into the JD program, be admitted into the JD program, and transfer credits back to their undergraduate institution. I was in some conversations with some undergraduate institutions in which they wanted or were interested in perhaps allowing their students to take JD courses to meet some of their undergraduate requirements. But the student may be interested in law school, but it wasn't confirmed that they were. So the question came for me is there a way for them to use the credits that they took in their JD courses, and if they decide to matriculate, to actually, could we apply those towards their JD degree? So after looking through the guidelines allow for transfer credits, but only if you've already been a JD student, either an accredited or in a registered school. There was no option for a visiting or auditing student to actually use those credits if they decided to matriculate into law school. So I, after speaking with George and recognizing that this was a much better thing, not as an individual school kind of policy or request, but rather something that all schools could participate in with a guideline change, sent some proposed language out to my Cal colleagues and asked my Cal colleagues what they thought of this, and I got some helpful feedback. And so you received an initial motion in the material, but I want to just amend it a little bit. You received a very hurried attempt to amend it, but it's got some typos in it. I don't do well when I'm hurrying. I don't do well when I'm slow either, but it's especially bad when I'm in a hurry. So the proposed amendment, the motion is that RAC recommend to the CBE the following additional guideline 5.10. Credit may be allowed toward the JD degree for up to 12 semester units of coursework taken in the admitting school as a visiting student pursuant to Guideline 712. So Guideline 712 already allows us to have visiting students in our classes, and so it would be consistent with that. To receive credit, the visiting student must have taken the course or courses within 18 months of admission, must meet the pre-legal education requirements in Guideline 5.1. That was a really important addition because that way we're not going to have a high school student in our JD courses, but in fact have someone that could be admitted. Must have participated and been graded in the courses as equivalent to a JD student, and must have received a grade that leaves them in good academic standing. So the hope is that this would allow just another way for people to be introduced to legal education, have the opportunity to experience it, create some cost savings if they decide in a reasonable time frame that they want to attend law school, and that they are in fact admitted at a subsequent date.
Okay, thank you. Thank you for that. Once again, let me, before the committee discusses it, offer the opportunity for public comment on this one. Dean Winnick? Dean Winnick? 3 minutes, go.
That will be a challenge in and of itself. But, first of all, let me thank Dean Gardina for thinking about this. I suspect that when the original rules creating CALs that allowed us to have students with 60 units versus a bachelor's degree was probably a very controversial thing. But the origin of that was to create what we have become, which is opportunity law schools. And I think this is another very creative way to continue that process. It's very thoughtful. I don't think it diminishes our programs, but it continues this idea of opening the doors to legal education to individuals who might otherwise be intimidated to it from cost and time commitments. And so I would like to say I think this is very thoughtful, shows that there's a dynamic to legal education that needs to continue to recognize the population and those we're trying to attract. So I think this is a very good idea for the committee to consider. How'd I get?
You got it. Please.
Boy, don't tell him that.
I give my time back to the chair.
Very good. Any other public comment on this one? Yes. Dean Desi. Do identify yourself.
George Desies, I'm the interim dean at San Francisco Law School. Dean Gardena, I thank you very much, and I think this concept is very worthy of consideration by this committee and the Committee of Bar Examiners thereafter. On a very mechanical note, just to call it to yours and others' attention, the final criterion or condition, it says, and must have received a grade that leaves them in good academic standing. Did we mean to say that the grade in that course would be at the good standing level? Or that that grade, when calculated into the cumulative GPA?
Yeah, I had originally had that they had to have a passing grade, and then it was identified that that's
what I thought.
So it had to be, so it's meant to be course specific, not they take 12 units and they manage. So yeah, point taken, it's supposed to be, at least the way I imagine it, in the course itself, not over the course of those 6 or 12 units, whatever it would be.
Yes, and I didn't mean to be persnickety about it, but
No,
if it goes through the whole process, I can imagine myself and others looking at that rule and saying, you know,
Yeah,
it might be confusing. Thank you.
yeah, thank you.
Yes.
Thank you. Any other comments on this one? All right, to the members of the committee then.
So,
This is an action item. This is a.
Yeah, and let me just say, I think, Dean Gardena, I think it's a good idea, and I think it's thoughtful in terms of, it does provide people that may not have thought about seriously committing to law school, and gives them that opportunity to do so at undergrad, and then take the advantage of having essentially a semester's worth of credit that can transfer over, which I think is a cost savings, and as Dean Winnick said, law school's of opportunity. So I think that this is, I think it's a good step in the right direction. And certainly, and if we want to, and really we do want to encourage people to think about legal education with the idea of what they can really do to improve the communities that they're in, as opposed to thinking somebody else is going to do this. Because we're learning now, if you don't do it, it doesn't get done. So I think it's a good step.
Thank you. Other comments from, yes?
Just perhaps, just for wording, maybe instead of that leaves them in good standing, academic standing, say that leaves the student in
Yeah.
good.
And I'll pass around this new.
Or could you just say, and received a grade at the good standing level, at the level of academic good standing? By the institution's definition, or however you.
If I may add on that point, may I be recognized? Yes, no?
You may, Dean Desies.
But just in keeping with the language as it appears in guidelines 5.7 and 5.8 with regard to awarding transfer credit, one in the case of students who have been previously academically disqualified and those who have not. And I don't have it in front of me, but I believe the language says receives a grade at the good standing level from the awarding institution. So, thank you.
Thank you. Other comments from the staff or the RAC? Yes.
What is the nature of what we're considering right now? Is this language meaning, is this a recommendation to the Committee of Bar Examiners to start the process of evaluating whether this is a good idea and then taking into consideration other issues?
So we don't have a motion on the table
No, but
formally,
okay.
and so what I would entertain is indeed a motion, and whoever makes it has to tell us what exactly they're moving. But first, George, staff comment?
Well, I communicated with Dean Gardena on this point. I mean, the normal process would be, so whatever the RAC would recommend to the committee would go to the committee at its next meeting, an agenda item for its review, approval, and adoption in principle, and whatever form it would come out of this process. And then it could come back to the RAC just for final confirmation, but the committee couldn't look at it until their next meeting because it'd have to be posted. And then at that meeting, as normally would be done, if it was adopted in principle, go on to public comment, come back from public comment, come back to the RAC, and then have it sent to the committee for the last adoption on a date certain. So you're looking, probably no sooner than June, and maybe by August. But that would be the normal process.
The reason why I ask is, we earlier today had a meeting of the deans of the Cal Accredited schools, and some people had some very positive and other suggestions to this language, and I had some concerns about how the students would be graded, and the impact that those students, if there was a group of students who were not JD students tossed into the rest, how the impact that might have on the other students in the class. If I'm because all grading is done in an anonymous fashion, and so I'm all in favor of this proposal going to the committee, but I also believe that there's some other considerations that could be made, and at the committee level as to the best way to implement this policy without having a negative impact on the academic program at the school.
All right, so I'm a chair in search of a motion here. Is there a motion?
So my original thing I sent around, there's a motion, it's a motion to have the RAC recommend Guideline 5.10 to the Committee of Bar Examiners for, is it approval or consideration?
Well, be specific. Adoption.
Adoption.
Would be if you want them to pass it and put it into place. Study is a different thing.
No, not study.
I think you want to adopt.
I do.
No study.
Not study.
And it's adopting the language as amended.
Yes, as amended. And I can read it as I have it right now, and please correct me. I want to go to actually Guideline 5.7 and 5.8 to make sure that the language matches the two, but I think I've got it. Credit may be allowed toward the JD degree for up to 12 semester units of coursework taken in the admitting school as a visiting student pursuant to Guideline 7.12. To receive credit, the visiting student must have taken the course or courses within 18 months of admission, must meet the pre-legal education requirements of Guideline 5.1, must have participated and been graded in the course as equivalent to a JD student, and must have received a grade at the good standing level at the awarding school. That latter one would want to grade.
And do we have a second?
I'll second.
Second by Karen. Do we have further discussion? We have just a technical moment.
While they're reading that, this is
Further comment, yes.
The term 18 months of admission, does that mean, I'm reading this, the visiting student must have taken the course, of course, within 18 months of admission. Is the intention of that they are now applying for admission to the law school?
Yeah, I was trying to match it with the transfer of credits from law school, which is 2 years, but that seems too long for what we were proposing. So it was supposed to match that 2-year limit, but limit it to 18.
Dean has a good point. I mean, it does beg the question whether or not these undergraduate students are being admitted to law school at that point in time, or are matriculating, perhaps is a better term of art, because they wouldn't have gone through the entire admission process. I mean, they would have to be qualified to be admitted under 5.1, which is what you got. And I'm just saying, that's just one thought I have is if a CALS were to allow an undergraduate into this program, what's the process? I mean, would they go through the full application process that someone applying to law school would, or something less than that?
So, in my mind, this has nothing to do with the admissions process. The admissions process is distinct. They would still have to go through whatever the school's admissions process is. This is that you wouldn't get credit if you took that course 2 years before you were admitted into the law school. You would have had to take the course within the 18 months prior to admission into law school.
So I'm just talking about, so the undergraduate with an idea of one earning credit at a CALS to apply to their undergraduate degree would then apply through the normal process of colleges or JFK or any of these schools to then be admitted, and they could be if they have the 60 units. And if they were worthy of admission, then they're admitted to the law school, at least initially. Well, they're admitted to law school. They can take those classes, go back, graduate, and then continue on with the JD program.
No, I'm sorry. That's we're talking about two different things. They're not. They're taking this course before admission into the law school.
So that's my guess. That's what Dean's point is.
Yeah, well, I had that, and then I had another question is, and I don't know what the intent is, but if a student takes 12 units at the colleges of law and then decides they want to enroll at San Francisco Law School, would you envision that San Francisco Law School could accept those units?
That's not how the proposed guideline is written. So if that's something that you want to amend, that would be something. It's at the admitting school.
Yeah, no, that's what. Yeah.
So it's specific to the admitting school, and this is pre-admission coursework, not post-admission coursework.
Admission to the law school.
Correct.
So I mean, and then again, from a regulatory perspective, I guess what's the, again, just considering this for the first time, the check, I mean, what is the guarantee that an admitting CALS would know that this undergraduate is in fact worthy of attending and getting credit at their law school if they're coming from another institution and they haven't applied and confirmed?
Absolutely. This is one of the discussions that came up with the CALS deans, which is why we put in that they have to at least meet the pre-legal education requirements in Guideline 5.1. And then ultimately, they have to be graded equivalent to a JD on an anonymous level, get a good standing or higher grade in order for those credits. So in terms of worthy of admission, that's not the question that I think this guideline is asking.
Well, I'm just asking, I know, because it just raises the question that your colleges, I mean, if you got contacted by an undergraduate who said, I want to take these courses and now I have the authority to give these credit, the question then is, if they're not going through the admission process, how would you know that they, in fact, have met the requirement of Rule 5.1, which is 60 acceptable units?
They would be required to establish that before they could sit for the courses and get credit. If they want to get credit for these courses, then they would have to, we as the institution would have to establish that they met the pre-legal education requirements of Guideline 5.1.
And I guess you could do that in your admissions process to say you'd have a separate, I mean.
Right, it would be, I want to be a visiting student with the hope that I can, if I decide to pursue a legal education, that these would count towards that. They could come as a visiting student now, and we could allow them in. This is specific to a visiting student who may want to apply those units.
It's to give them credit. The issue is you now give them
It's
credit.
whether or not they're going to have credits available to them. The visiting student guideline already exists. This is, can that visiting student have credits applied to the JD if they were to be admitted within a certain time frame?
All right, if there are other comments from the committee?
No, I think I have it from 5.7. It says, and must have received a grade at the good standing level or higher at the awarding school, which would be consistent with the transfer credits from a previous JP institution.
So procedurally, are you proposing that as an amendment to your motion?
I am. Would you like
The
me to
addition
read
of
the
or
motion?
higher.
I will read the motion again. The
Okay.
motion is that the RAC recommend that the CBE adopt Guideline 5.10. Yes, the proposed guideline is credit may be allowed toward the JD degree for up to 12 semester units of coursework taken in the admitting school as a visiting student pursuant to Guideline 7.12. To receive credit, the visiting student must have taken the course or courses within 18 months of admission, must meet the pre-legal education requirements in Guideline 5.1, must have participated and been graded in the course as equivalent to a JD student, and must have received a grade at the good standing level or higher at the awarding school.
Awarding school or institution? I believe you said institution earlier.
Did I? We use admitting school at the above, so I could do,
So
should
what's
just
it?
be consistent, change it to institution in both places.
Whichever you like. I just pointed out which way it was before.
The guideline says law school.
Can I make one more suggestion?
Yeah.
Well, to capture, for instance, if you pick in schools on a quarterly, after 12 semester units, when, or their equivalent, so that it would be clear that it would apply to schools either on a semester or a quarterly system.
Oh, God, that's mine.
You're wondering,
Yes, it is. You should be so glad you're not in federal court. Come you're gone.
What idiot, I'm sure.
So let's just take it back for a quick second. The 5.7 guidelines say the admitting law school. I am informed.
Yes, I heard that information as well.
Would your
Yes, I accept that amendment, and I would say the awarding law school as well. All right,
at the end, so the admitting law school
at the
in the
top.
first line,
Yes,
and the awarding law school at the end.
yes.
Okay. So with those amendments, Karen,
Yes.
your second?
Second.
Second?
I have another comment.
Another comment?
Well,
Okay.
I just, because this is a big thing, we're making a recommendation to the committee, and there's all these issues that are going on through my mind about problems with, potential problems with this, and I'm one, why would we limit the units to be only to the school where the student served as a visiting student? I don't know why, if say I used before, San Francisco Law School wanted to, if it was good enough for your school, why couldn't San Francisco Law School or Humphreys or someone else do that? And I'm just trying to get my head around it.
Totally, and I think again, when I was envisioning this, I wrote it through a very myopic view, which is an agreement between an undergraduate and that shared credit idea. So it was with the idea of creating that shared experience between the undergraduate and the law school. But there's no reason that the guideline has to be so narrow. It could be taken in an accredited law school to match the language of. So I would not be opposed to a friendly amendment.
Are you proposing an amendment to eliminate the words "in the admitting school" from the first sentence, so that it then reads, "Credit may be allowed toward the JD degree for up to 12 semester units of coursework taken as a visiting student pursuant to Guideline 7.12?
Yes.
Is that what you're suggesting?
Yes.
That
I would accept
is that an
that
adopted
friendly
amendment? You would accept it? Karen, would you
Yes.
second with that modification? All right, with that modification, are there any other comments on this language? All right, would you like to take a roll call vote on this one? Counsel?
Yes, or I don't know that you've ever established that you have your quorum, and so
Right,
you
so
need something like that.
let me note for the record that all members of the RAC are present for this meeting. So we have a full quorum. Let's do a kind of a roll call vote on this to be sure that everyone is aligned on it. And David, you'll take note. Can you call the roll?
Yes. Barbary? Yes. Brandis?
Yes.
Gardena?
Yes.
Goodman?
Yes.
Hiramatsu?
Yes.
And Lynn?
Yes.
Everyone's present.
Thank you, David. Appreciate that. Okay. That takes us to our next item on the agenda, which is the definition of substantial compliance for schools applying for provisional accreditation. You received a memo that contains some research resources about this issue. That memo attempts to give you a sense of what appears from the research that I've been able to do to be the norm in applying this term. And let me just set this up a little bit, and then George, I'll pass it to you for any further comments on this. The use of that term, I should say, first of all, that term is used in several different places in the rules. The memo attached to the agenda lists those places, or at least most of the ones that I was able to find. It takes place in 3 different contexts. They essentially mostly apply in this situation where a school is applying for provisional accreditation, where the standard applied is substantial compliance. A second context is with respect to formation of new branches or satellites. It's used in several spots there, and it's also used in connection with probation for schools. The most common use of those schools applying for provisional accreditation. My research discloses that there aren't a lot of formal definitions of that term. There are some in other domains of expertise, other fields, tax law, for example, other places where it comes up. In the accreditation world, in general, it's applied essentially as a judgment call by the accreditor, without much in the way of guidance as respects what that means or how to evaluate substantial compliance with the regulations. And so I've tried to offer some of the ways that it seems to be applied practically in the research materials that I provided. And I should say that this is essentially kind of a first read or a first approach to this language. I don't expect it to necessarily be voted on in this fashion today, but certainly it's a conversation that we ought to have about what that actually means, in as much as this kind of thing may come before the committee in the future. It certainly probably has in the past as well, and there's probably some institutional knowledge about that we should share as well. So I wanted to open the item for conversation.
And if I can add one more thing to this discussion, and that is in one of the CVE agenda items, item 400 tomorrow, this is the JFK proposal. There is a recommendation from staff to go back and revisit the guidelines against the rules, and I think this area, determining substantial compliance versus full compliance, I think is a really good topic that needs to be addressed in that process, because I think more specification in that distinction is probably more helpful rather than leaving it open and as subjective as it could be.
Yeah, and I forgot to say one thing the one thing that is clear is that substantial compliance is not full compliance. So just by definition, the two are not the same thing. So you can't expect full compliance with all applicable standards and call that substantial compliance. That is substantial compliance, but substantial compliance by definition is something less than full compliance. And so the nature of that something less is really the topic of the definitional work that I invite the RAC to discuss. George.
Well, thank you, Dean. Let me try to give everyone a practical view from the practical level, what it means, and it's even more timely now, particularly what Donna just mentioned, that moving forward with the committee, more likely being in a position and having the authority to start accrediting online law students. and other unaccredited schools that, including fixed facility. And the clear metric that these schools will be judged against, and among the most important, will be the 40% minimum pass rate. The process is well established, where any school that thinks it's worthy of provisional accreditation can apply, and then the application is received by staff and then the committee. And if it looks, at least on paper, that the school is in a position to be found provisionally worthy of provisional accreditation, an inspection team is put together, and they would go out and inspect the school. And when you go through the guidelines, and that's the rule, that the school has to be in substantial compliance with all of the committee's accreditation standards, it often boils down to a good faith, objective, and sometimes subjective decision whether or not a school's program of legal education, the quality of the teaching, examinations, the grading standards, do they pass muster? Can the team both make a finding and recommend to the committee that, in the team's opinion, yes, the school is substantially compliant? Well, with most, if not all but one of the rules and guidelines, there's some point of debate. The one area that is a very clear, bright line metric is 12.1, which is the 40% minimum pass rate. And so the question has been discussed, I think, very briefly at the RAC some time ago. It wasn't as relevant then as it is now. But the question will be, in the near future, when teams appointed by the committee go out to any type of registered school, fixed facility, or online, and they write the report, what do they say if at that time the school has done the math, they've done their numbers, and their NPR is, let's just guess, 38%, 36%, 39%, or 34%, somewhere less than 40, but say above 30. And I believe the committee should at some point make a policy decision but this is a good conversation starter to do just that, because there's a competing policy at issue, and that's going to come perhaps even more relevant than accrediting new or finding registered schools worthy of provisional accreditation. And that would be the committee's enforcement of 12.1 in terms of existing CALs that have been found to be below 40%. And so if a CALS is to be issued a notice of noncompliance, and they're at any of those numbers, 38%, 36%, whatever that number is, and technically speaking, under the guideline, they are worthy of a notice of noncompliance, obviously you can see the tension between an existing CALS that is going to be at risk of being put on probation and possibly even losing their accreditation, who has established in the most relevant and most recent reporting periods below 40%. How does that play in terms of a registered school being granted provisional accreditation that isn't at 40, but maybe in the same, within again, between 35 and 40%, just by way of example. So that's kind of the policy decision that I think moving forward, the committee certainly, along with the RAC's assistants, should discuss, debate, and eventually establish this, because I think it would be fair to have that metric established. I mean, if 40% means 40%, then it tells all the schools whether or not they should proceed and are really worthy of accreditation. Because, and this has come up in the not too distant past, where a school has been found to be worthy of accreditation, they're in compliance or clearly substantial compliance with everything but the NPR. And, in lieu of having their application denied, they've withdrawn it because they're confident that recommendation would be to deny it. But they don't have, there's no staff currently, and for the foreseeable future can't tell schools, as this discussion takes place, whether or not they should take the time and effort, because it's a time-consuming, expensive process to prepare for and get ready and apply and then go through the inspection process. And not knowing what the committee is going to do, I think, is a disservice to the schools and really to the committee's efforts to enforce its minimum pass rate, both by existing schools that will be found below the minimum pass rate of 40%, and schools who are below 40% but believe in good faith that they're entitled to provisional accreditation. So that kind of sets the stage for that.
Thank you, George. So again, this might be an item on which there is some public comment. Let me offer the opportunity again. Dean Winnick?
Thank you. If there's ever going to be an issue that makes our head explode, it will probably be this one. This is really complicated, but very, very worthy of the RAC's attention. And I appreciate that you brought this forward. Because as George says, there are a lot of permutations in which this would come up. And so I'm thrilled that you're starting this discussion, I think open discussion of it. You know, George, to your point, let's just talk for a moment of think about a school that's applying and we're trying to get them to that 40% pass rate. It's a cumulative rate, and we've watched their first time rate go 35, 36, 37, 38, 39, 40, right? But for them to get cumulative 40, they're going to need to go 41, 42, 43, 44. You know, so it could be 10 years for them to get to a cumulative 40, even though by almost any measure, everyone would say, that school's really doing well. They're both conceptually and practically moving in that direction. So I don't have an answer, but I think the fact that you've brought that out on the table really helps us. I would give rise to the question that we're going to want to consider whether the baby bar comes into play for existing schools that have had a baby bar rate that's been exceptional for a number of years. Do we give some credit to that? There's nowhere in the rules that would let us do that yet. And yet it would seem from a policy standpoint, that might be something the committee wants to consider would be worthy of substantial compliance on this. The difference between a school that's brand new, showing up day one with a piece of paper saying, I've got $5 million and I'm starting a law school and here are all the resources I can put into it, versus a school that's been a small school. And they've built themselves up over 10, 15 years, and now they're ready to make the leap into accreditation. So I think there are going to be countervailing balances. Again, don't have the answer, but I think this is probably one of the most important things for this committee to be thinking about over the next months. And I think it's really helpful to get started on this before we have to actually apply it to this transition of registered schools to accredited schools. Thank you very much.
Thank you. Other public comment on this one? First, in the audience? All right. Let's take it back to the RAC and to the staff. Let me add just one notion. My notion in bringing this to the group was for the group to focus on a general definition that will then guide the further work that the committee does and others do, staff and others, in determining some of the specifics as it applies to rules like the NPR. So rather than come at it sort of from the detail to the general, I suggest we come at it from the general and then go to the detail. And I think that that's probably more helpful in terms of what the committee can actually consume and use, as opposed to trying to address all the possible places where it might come up, to provide some sort of overarching notion of what that means. That's the nature of the conversation I was hoping we would have today, recognizing there's a lot more work to be done to get into the specifics on particular guidelines and particular rules. So with that framing, if I could, let's have the conversation among the committee. If any.
I have to say,
Dean Barmia.
what conversation are you looking for? My feeling is this is a great discussion. I echo everything that Dean Winnick said. I think this is not a simple thing, and there's many aspects in our rules and guidelines where this appears. And so my question for you is, what are you looking for? You brought this forward today. I'd like the committee to consider it. I'd like it to be worked on by staff, and it might not be applicable or limited to just this. It might be involved in moral character determinations. It might be involved in other things. And bringing it back to the committee for a discussion on substantial compliance, I think it's fantastic. So I keep coming back, I was like, what would you like to see, what was your hope to see today?
So I would like to see, if you look at page 2 of the memo, where it says substantial compliance as it is used in accreditation. There is kind of a summary that seems to be the prevailing definition of that is applied by accreditors. I'll just read it out for the record for the benefit of those watching at home. Substantial compliance is demonstrated where the overall combined effect of the school's performance in regulated areas generally satisfies the overall purpose of the regulatory scheme, and the institution has demonstrated the capacity to operate compliantly by the end of the permitted time frame, even though non-compliance also exists and is permissible until full compliance is required. So, for example, by the end of the period of provisional accreditation. That seems to be the way it's actually applied. So, for example, in the case of a brand new school, as the memo details, the school would probably not purchase the library materials until they were approved. And that means there's no compliance on the library requirement at the time of approval, 0. But they have demonstrated a plan and capacity and intention to follow through on that requirement at the time they're being provisionally approved. So that's where the question comes in about what we mean in general terms by substantial compliance. And I think as it is used by the majority of accreditors, it really represents demonstration of capacity and resources and commitment to meeting the standards that can't already be met at the time of the application. For example, in the case of a new school that's applying for provisional accreditation. In the typical world, by the way, many places, of course, there are brand new schools. They come in, they go right to the accreditor to attain provisional accreditation before they have their first student. There's nothing on the ground except what they can demonstrate in terms of capacities. So I guess the direct answer to your question, Dean, is does the RAC consider this to be the kind of definition that represents substantial compliance? Have you had enough time to think about it? Do you want to talk about it some more? That's really the nature of the inquiry.
But maybe as a swan song here, I mean, the RAC and the working groups. I mean, one thing, this issue could be addressed on a guideline basis. I mean, for instance, 12.1, with discussion could be amended to provide substantial compliance for purposes of this guideline is X. The same thing with branch campuses. You could say substantial compliance of the committee's accreditation standards with regard to branch campuses is Y. But I think it should take somebody, representatives of both staff, committee, and deans to go through those guidelines and identify where this term is used and how and why it's problematic in terms of an inspection team or giving guidance to both the committee and a team inspecting the school to say, here's the policy. You need to be this fall right as right, because this is a pretty bright line metric, either with regard to the hard copy library, say, or bar passage, resources that a branch is selling. You could identify, I think, where in the guidelines there ought to be a decision by the committee to set some kind of clear standards to what provisional accreditation means to that guideline.
Yeah, so again, that's a difference where maybe we have a difference of view about process. I think it might be more helpful to begin with the general and then move to the specific, whereas, of course, you can start at the specific and then work your way to a general notion. This term is used in a lot of places in the rules and guidelines, but there is no definition of it anywhere in any of those tools. And so we could develop a definition by starting with the specifics of individual rules. I would think it might be more useful to begin with a general definition and then have the later detailed work of implementation and interpretation on particular guidelines, because that will, to use a flippant expression, take years and cost millions of lives, right? I mean, the detailed work of looking at every one of these things is a very, very lengthy process. And I'm not sure, my personal opinion would be we would do the committee bar examiners a greater service by helping them see a general definition that could then be used in that process rather than beginning with the specifics. And others may
Yeah,
differ.
I mean, I think this is helpful, and just to think about this I can think of sometimes where my one concern is it's so subjective, and I think that's always the issue is, do we think because we like the presentation and we've got no people that perhaps, oh, that's close enough for government work, right? And yet somebody else comes in that we don't know, and we're going, oh no, that's not, and that's the problem by having language such as substantial compliance with no definition whatsoever. So, and I can envision circumstances when you actually get into the details where there may be something that we're going to say, like George has just said, where substantial compliance is not good enough because of the public protection concerns, overarching policy concerns. But I do like the idea of having a definition of what we think substantial compliance is, which I would think is that the school is working on this target in good faith. And even though they're not 100% on board, all indications are they're getting it. And that's how I interpret your definition. So I think it's a good start.
Are there other comments?
I would just like to see it equally applied to bar examination scores, so if someone doesn't like
I don't think
they
that's
substantially
within the RAC purview. I'm just saying.
The law school council.
I don't think it's our charge to do that.
All right, I'll withdraw my suggestion.
Is there a motion about this, or further discussion?
Yeah, I like the direction that this is going. I think I need a step back and understand what we're trying to do. Is it your suggestion that we will eventually get to a place where a generic definition will be embedded in the rules and or guidelines? And then, as George suggested, perhaps for individual guidelines, having a more specific notice to schools so that, and I'm thinking when we have students who are subject to or want academic probation, there's some bright lines that we have, like this person is not mathematically ever going to be able to achieve what they need to achieve here, and it's much better if we say, good luck. And then there's those that you think they've got, so I think there are places where there's bright lines, and so is it our intent to say this is a good starting place for a substantial compliance, and then say, or as further refined in individual guidelines kind of thing? Is that what we're talking about?
Yes, and I think there's a question procedurally whether those interpretations or end up as guidelines, or are they CBE policies, for example, or are they internal staff guidelines? Ideally, probably they would ultimately be something like CBE policies or an actual guideline that states what the measurement is. How far along this path do you have to be in order to meet substantial compliance? I think that's a big project, and the committee may be facing decisions on substantial compliance far before that project can be completed, I think. And so I think I'm suggesting that a general definition would be at least useful to the committee as they move into this, and then also useful in terms of the staff work that has to be done.
So right now you're talking about recommending a guiding principle rather than something that is explicitly recommended as a addition to the guidelines in order to.
Well, actually, no. There are definitions. There's a definitional section in the rules, and so the outcome of this conversation could be to propose to the committee the adoption of a definition of substantial compliance for inclusion in that definitional section of the rules and or guidelines.
Correct. I guess what I thought I heard you say is that the process to get there is long, and we might need to, or the committee will be making substantial compliance recommendations or decisions before that might be embedded. So are we recommending a guiding principle in addition to and embedding them into the rules and guidelines.
I see, distinction. So we were talking about the specifics on particular rules and guidelines. That could end up being a guideline at some point, but that isn't the definition that I was referring to. I was referring to the more global definition to be included in the definitional section, and then guide the rest of that staff line.
I mean, if memory serves me right, I mean, the root of this issue is in the rules that talks about when a school, when the committee is worthy of provision. And they talk about substantial compliance there. So, you know, amending the rule in a way that be consistent with what you're saying, I guess might be the first step of the process, because that's going to require board approval. And then once you have an adopted definition, then you could work off that on a more ad hoc basis, as I suggested earlier, with regard to any specific guidelines in 12.1 and 15.1 and most obvious. But I think you need to start at the rule.
And that's where the definitions live, and that's where many of the references to substantial compliance also live, is in the rules themselves. So that's the nature of the conversation. Does anybody have a motion on that, or should we put this over the next time, or what's the group's pleasure?
When Amy mentioned that this was a part of the staff recommendation with regard to the agenda item dealing with JFK's branch campus thing, what is that something that was part of the staff recommendation or not?
Yes, it was part of the staff recommendation, and substantial compliance was not outlined or specified in that suggestion. However, it might be one area that they want to look at.
The staff. Oh, go ahead.
Yeah, the recommendation was the staff recommendation is more general that the committee direct the staff to look at the accreditation guidelines.
For branch and satellite.
For branch and satellite.
Take a look at the branch.
That's what I was trying to remember back. It was limited to those instances, and what Greg's talking about is a broader application and definition and use of substantial compliance.
Yeah, I don't know that it was just branch, but so we didn't pull out substantial compliance. That would obviously could be one of the things that would be looked at, but that doesn't preclude you from going forward with a recommendation now to adopt a definition of substantial compliance. Then there's no reason that would prevent you from doing that.
Right, and the reason why I ask questions, I just don't want to have conflicting recommendations going forward to the committee. My feeling is there's a general consensus among the RAC members that this is something that the committee should look at in many different ways. And I think there's, from the staff recommendation, the staff inclusion in an agenda item, there's a recognition that it's something to look at as well. And I just want to be careful that any recommendation or motion coming out of RAC is not interpreted as something different than what might also already be in motion or in process.
So I'm looking up the agenda.
Okay, you can clarify. So I apologize for saying that if I'm wrong.
And while I do that, can I make, what worked well for the branch campus guidelines, I mean, when you've got this major issue to be discussed, I mean, what's worked in the past well is the deans would submit a proposal, and then there'd be staff proposal, and we would sit around and discuss, and through a lot of hard work, a collaborative effort, you come up with a proposal to RAC, and then recommend, and then go through the same process. But I think what's worked best is where both sides have issued what they think it ought to be, and then come to some eventual agreement.
So you were 100% correct.
Oh, good,
The-
for a change.
That's why I like to point it out.
Appreciate that.
The issue that will be discussed by the committee tomorrow is that the branch and satellite rules have been sort of looked at after they've been tested each time, and so that we should we're recommending that the committee direct staff to again look at the branch and satellite guidelines where we talk about to assist the committee in its determination of whether CALS has offered a plan to open a branch campus that is substantially compliant with the rules and guidelines. So it is sort of limited to that context. So I would restate with sort of greater certainty what I said before that there really wouldn't be a conflict in this case.
Jeff.
Yeah, Greg, when you were describing substantial compliance, you used the terms resources, intent, and capacity. And in your kind of little pull out there, you just had capacity. And I'm wondering if, and again, I think about this in terms of those students who want to stay in law school, even though they haven't necessarily demonstrated the intent to work to their, they might have the capacity, maybe they've got a high GPA, by all intents and purposes they should be succeeding, but they just either don't have the resources or the intent to do so. I'm wondering if we want to do something more than capacity in there. If we were to start with that as our starting place for thinking about a general definition. It says demonstrated the intent, the capacity, and available resources to operate compliantly by the end of the time frame.
Is that in the nature of a motion?
Friendly amendment, I guess. Oh, are you?
I don't have a motion yet to
Just
amend. I'm not
waiting.
making a motion.
I guess
just chairing.
what is preventing me from making a motion is this feels like a really big deal. And so I would love to roll it around a little bit more because I think it's a really important definition. And it's one that's going to be applicable to the CALs, not just those who are coming into the accredited, but all of us. So I would love maybe to even, we didn't have a chance to talk about it among the CAL deans. I'd love to have an opportunity to give people a chance to kind of play with the language. I thought my motion, which started out pretty kind of shallow, got better and better and better. And then it just got annoying after a while. As people kind of brought in their thoughts and experiences into it. So I guess my hope would be to perhaps table it for this RAC meeting and bring it back to the next meeting, and hopefully with an opportunity for all of us to kind of participate in thinking through some pluses and minuses to this.
Sure. And I'm happy to do that. As I said, this is kind of a first read.
Yeah.
So I'm just asking the question if there's anybody who's in that spot. But we'll bring it back on the next agenda, having raised everybody's awareness, I hope, with and think about it. So put some time in thinking about it between now and then.
And thank you for the work that you put into just kind of bringing us to this place. And I think it's a really important discussion, so thank you.
You're welcome. Great. All right. Well, let's go on then to our next agenda, which is the goals. As I've indicated before, these will continue to be on our agenda just for a check-in in respect to the work that we're working on. As you can see, we've tackled one of the additional ones today that we hadn't discussed before. And we've done some work on minimum compliance, again, informational work for our consideration for the future. We still have a couple of items that we haven't tackled as yet with respect to trade secrets, for example. So you can expect to see that on an upcoming RAC agenda as well. And our agenda is starting to get very busy for future RAC meetings. So that's just a check-in on the rules. Does anyone, or on the goals, I should say, does anyone have any additional suggestions on goals or comments? I imagine not. Usually not at this stage of the game.
Additional goals?
These are the goals we've refined for the year. So refinements, perhaps, but probably not
Yeah, good, yeah.
brand new ones.
I have lots of goals, but I don't think it's
All right, that's good. All right, so thank you, everybody. So that brings us to our last item of the day. And our last item of the day, of course, is we want to recognize the work that George Leal has done over these last, is it 8 years, George? I think it's 8 years. As the director and now program manager of Educational Standards, working with the Committee of Bar Examiners, also working with both the Cal Accredited schools as well as the unaccredited schools. And this, of course, is sort of a notion that the RAC recognize this work. I think, George, the most important thing to note is that throughout your tenure, you made a great deal of effort to understand these schools, to understand the mission of these schools, and though we frequently disagreed with, as we did in the meeting today, as a matter of fact, about processes and other things, it was always evident that it was your passion that all your work resulted in the improvement of not only individual schools, but also improvement of the schema of regulation of legal education in California. Obviously, many of us are interested in access to justice and in maintaining the ability of these schools to deliver an education to a diverse population at affordable and accessible levels. And your work in crafting rules, and also I know how hard you work in making recommendations to individual schools in the process of inspection to ensure that they're improved by the inspection, not simply that compliance is determined, but also to offer them paths to become that much better. And I think I speak for all the schools in thanking you for your devotion to that additional assistance to the schools, even though at times we may have disagreed with those recommendations too. So this is an acknowledgement on the part of the RAC, and we appreciate your passion and your service and collaboration with the schools in improving the system of legal education.
Well, thank you. Very kind and very, very much appreciated, and thank you, Craig. And let me just say briefly, certainly what now is becoming a relatively long career, getting to work with the committee and serving on the committee, and getting to know committee members, and also working with and alongside Cal's deans and unaccredited. We met when you were dean in Concord, and so I know and believe I've developed some very meaningful, long-term professional relationships and with people I respect, and I think it's fair to say that yes, I some time ago very much believed in and still do, and was very proud and motivated to work hard to elevate and make effective the committee's efforts to do what it does, which is, as we've said over and over again, be an incredible pathway to the profession, diversifying it on many levels, and providing a meaningful path for the access to justice. And when you talk about access to justice, what you really mean is giving everybody access to what is hopefully an affordable attorney who's well-trained, motivated, and effective advocate, no matter who you are or what you do. So it's been among my professional highlights to do just that. Now that this is on the web, I have a feeling I'm going to be watching whenever I can, and I look forward to seeing. And let me just say, Gail certainly played a major role in helping me understand and develop and training me where necessary. And a lot of my success came in part through her very able, capable, and very very helpful guidance. And I think she was a big part of it. But thank you all very much. I hope and suspect I'll still stay in contact with quite a number of you. So good luck, and we'll all be watching. Thanks again.
We'll all be watching. Well, with that, I think we're adjourned unless there's any other comments from members of the committee.
Good. Thank you.
Thank you. Thank you, everyone.
or one item, are you gonna schedule, when's the next meeting?
The next meeting is as published in our previous meeting, scheduled, it's in May, in connection, May 3rd, right? In connection with the Committee of Bar Examiners, the Thursday before the Committee of Bar Examiners.
Is that May? Is that May?
Thursday, May 3rd. Great, thank you everyone, we stand adjourned.
You are David.
I'm David, yes.
George Dennis.
Nice to meet you.
Nice to meet you.
And there's Kate.
That's why you like-
No,